Good morning, and on behalf of Hansuke and WTS Global, may I welcome you to the final webinar in our DAC6 Academy series, DAC6 and the main benefit test. Now, please look to the right of your screen and familiarise yourself with the platform. There is a chat bar as well as tabs for polls and questions. Should you miss anything, don't worry. You'll have access to the on-demand recording straight after the webinar. Now you're getting comfortable with the platform, please do use the chat function on the right of the screen to introduce yourself, and please let us know where you're from. Thereafter, do comment on the proceedings for the benefit of the other participants. You may also raise questions, and the panel will do their best to address it during the conversation, or they can pick the questions up at the end of the webinar. As you guys introduce yourselves in the chat, please allow me to introduce your moderator for today's webinar, Ali Kazimi, Managing Director of Hansuke.
Excellent. Thank you very much, Lucas. And as Lucas said, please do ask your questions and we will try to deal with them as we proceed. I'm really delighted to have our panel of experts with us today. And, without further ado, I will ask them to just introduce themselves and if they're kind enough to share one fun fact of their illustrious background that we might not have heard on their CVs. I'm sure you're familiar with all of them. But anyway, starting with you, Robert, who's on my left.
Thank you very much, Ali, for the introduction. My name is Robert Welzel. I'm a tax partner with WTS, located in Frankfurt and specializing in the financial service industry for more than 25 years. So covering cross-border topics, tax topics. That's from a business perspective what I do. From a personal perspective, usually during the summertime, I try to go traveling, do some sporting activities like trekking, etc. This year, no chance, and therefore I gained some extra kilos, as you see on the screen.
Jonathan, may I invite you to introduce yourself?
Yes, hi everybody. I'm Jonathan Schwartz. I am a barrister at Temple Tax Chambers in London, and my practice is entirely in the field of international taxation. I'm a member of the bars in England and Wales, in the Republic of Ireland, and Canada and South Africa. I also teach at King's College in London, where I'm a visiting professor, and I run the 2 international tax LLM programs, an on-campus international tax LLM and an online LLM. The perhaps unknown fact about me, which is one of probably a number that I have in common with Robert, is that one of my challenges with lockdown and working from home is to avoid the distraction of going and looking in the refrigerator every 20 minutes for something to eat and focusing on the task in front of me. But today I promise that I will participate fully in the seminar.
Thank you, Jonathan. And James, can I invite you, please?
Absolutely, yeah. Thank you, and good morning, everyone. My name is James Marshall. I work for HMRC, and I am the policy lead for the implementation of DAC6 in the UK. The fun fact I will share: I've been hoping to do a bit of travelling this year, and unfortunately my trip to Japan was cancelled, and instead I ended up moving house mid-lockdown. So I'm now here in sunny Limehouse. But the trauma of moving has certainly meant I needed another holiday, so I'll have to get something booked.
So with the challenges of lockdown, we have an unenviable task of discussing main benefit test and how it applies to DAC6. So one of the things that basically really did strike me when I first properly read DAC6 was, since 2004, in the UK, statute book, we have had in place this disclosure of tax avoidance schemes. The DOTAS scheme regime has been in place, and it's acted as a mechanism for HMRC to sort of just have an early warning or advanced warning system of any tax avoidance arrangements. And whilst it's been amended a number of times, it has kept up to date to a large extent, probably to reflect the changes, the evolving nature of the market for avoidance schemes. And through the DOTAS disclosures, HMRC has also sort of like introduced subsequent amending legislation to block any schemes that they considered were found to be aggressive or contrary to the intention of Parliament. Now, our audience may be thinking, why am I talking about DOTAS when they've come here to listen about DAC6 from our panelists? Well, the reason I'm talking about it is because, as I said, when I first read it, even a cursory look at DAC6 shows that its mechanisms are modelled on UK's DOTAS scheme. And the most notable difference, obviously, being that DOTAS is domestically focused, while DAC6 applies to cross-border arrangements. And in fact, some of the hallmarks have been completely modelled on the DOTAS scheme. So with that, if I can sort of like invite James to just share with us as to how he sees the DOTAS scheme working alongside the disclosable arrangements or the DAC6 regime going forward, because they obviously have very different reporting channels.
Yeah, thanks very much, Ali. And yeah, it's a really interesting sort of point to start off with. As you say, there are some clear similarities between the regimes. As you noted, I think some of the hallmarks are very similar, in the sort of the essence of the reporting mechanism certainly bears some resemblance with DOTAS. I think in terms of how that sits alongside DAC6, it's probably useful to look a little bit at the sort of the genesis of DAC6, and it sort of emerged alongside the OECD's work on developing models for mandatory disclosure in relation to CRS avoidance arrangements and arrangements that obscure beneficial ownership. Yes, so we can see those sort of mirrored in hallmark D of DAC6. At the same time, that as you know, DAC6 goes much wider than the NDR, and incorporates these other hallmarks. And as you say, some of them are very similar to DOTAS. I think there are equally we have to recognise they are two distinct regimes, and you correctly note that there are different reporting sort of mechanisms or channels, I suppose is perhaps a better word, for DOTAS and DAC6, and there's not really any sort of there's no exemption allowed for reporting under either regime where a report's been made under the other one. So the fact that something is reportable under DAC6, under DOTAS, doesn't mean it's excluded from reporting under DAC6. While that may seem, I guess, unusual, I guess the key point here is the exchange mechanism between different implementing jurisdictions, and the need to ensure that we're, that each jurisdiction passes the information to the other relevant jurisdiction. I guess, the other point to make, I guess, in terms of, that sort of overlap, is that while the UK has had DOTAS for many years now, not all the other implementing jurisdictions have had equivalent regimes, and indeed some have looked at to sort of take the opportunity for DAC6 to develop their own sort of reporting regime that does go wider than that. I guess the sort of the classic example is the Polish regime, which sort of expands on what's in the directive, and does consider sort of reporting of domestic only arrangements as well. So there are clear similarities between the regime, and I think in part some of that, the success of the UK's DOTAS regime in getting disclosures and helping HMRC to challenge avoidance schemes is no doubt part of the reason why those same kind of hallmarks are included in DAC6. But yeah, there are clear similarities that I think the two regimes going forward sit together, quite comfortably, and reports may be due under either or both.
And did you consider merging the two regimes at all?
So it was something that we looked at, but I think that the actual practical difficulty, because of the exchange requirements, we're going to make it too awkward. So the IT is beyond me to understand it, and so I won't try and set it out in any detail. But the IT challenges of having information coming in different formats and different routes meant that wasn't really practical for us.
Sorry, just one follow-on question, if I can ask. Say, for example, if someone has reported something through the DOTAS mechanism, and you look at this and you say, this really should have been on the DAC6 side of things. I mean, will the two regimes talk to each other? And, the intermediary may not have reported via the DAC6. You see that type of thing happening?
Yeah, so that does potentially cause a difficulty, because the information reported under DAC6 won't be exchanged with other jurisdictions by default.
Yes.
So for that reason, we do have to insist on reporting via the DAC6 mechanism for arrangements that are reportable under DAC6. So in that scenario, the person wouldn't have met their obligations in line with the disclosable arrangements regulations. There would obviously then have to be some consideration of the circumstances and why that had occurred. So whether the penalty regime would bite in that scenario, I think, would depend on the situation. But there would have to, there has a face value been a failure to report under the disclosable arrangements rules, which would be problematic from our point of view.
Sure. Now, turning to the main topic of the discussion, which is the main benefit test, it has caused much consternation within the industry, because we're trying to grapple with it. It looms so large and it's so big, its importance, that it has to be looked at properly. And with that, would you care to add something more, James, before I invite Jonathan to talk about the language of MBT?
Yeah, I have to say a few words there. So I guess there are a couple of points to make in regard to that. Obviously, as I'm sure people on the webinar are aware, the main benefit test only applies to some of the hallmarks. So there are ones where it's arrangements are reportable regardless of whether that test will be met or not. In relation to the ones where the main benefit test does apply, the test is obviously there to try and focus the reporting, to try and ensure that we are, we're making sure that the reports that are being made to tax authorities are the ones that are arrangements that are going to be of interest to us potentially, and to try and sort of minimise the reporting burdens for businesses. It's a topic that we gave quite a lot of thought to about how best to deal with it. The main concept of the main benefit is there in the directive. How that is implemented into UK legislation, something that gave us that we put quite a lot of thought into prior to the publication of the legislation and prior to the consultation, and we then refined following the discussions we had last year. We've then got the guidance that was published a few months back, which tries to sort of expand on that and give a bit of a flavour of the kind of things that we expect might be captured by it, and some of the things that we wouldn't consider the main benefit test to apply to. So it is something that we're aware of as being quite a point of interest. There are certain complexities to trying to apply it. I guess from our point of view, it's a challenge to try and find the place to draw the line, as it were.
Sure. So just on that, I'm going to ask you a very quick question, and then I'll let Jonathan come in. So if you can represent the views of HMRC, I mean, would you say the application of the main benefit test is more a science or an art?
That's an interesting question. I'm not sure I have a definitive answer to that one. I think
perhaps we'll pick it up at the end. With that, I'll go to Jonathan, please.
Well, that is a very 21st century question, if I may say so, Ali, because the distinction between art and science is something that only really emerged, I think, at the beginning of the 17th century. That before then, most people thought that all knowledge and understanding was more or less the same and connected with each other. So perhaps,
Jonathan, that's because you're a polymath. That's why. The real Renaissance man.
I don't know about that. Well, I think that one has to be in this field, perhaps. So before we talk about the language of the main benefit test, I think it's worth just putting it into a little bit of legal context. Mm-hmm. And that is that this is an instrument of European law, and it is a directive. And what that means is that member states are required to implement that into their own law. And the way in which they do that is generally up to them, as long as they achieve the objectives of the directive.
Yes.
Now, that being said, a lot of the work of the Court of Justice is answering the question, has the directive been properly implemented by the member states? And are the rights and obligations in domestic law actually reflecting what the directive says? And that means that in any situation, actually, we're always looking at two things. We're looking at the domestic law, and we're trying to form a judgment as to the extent to which it complies with European law. And one of the consequences of that is that there may be a range of implementation by member states, all of which could be equally compliant with the directive or equally non-compliant with the directive. And so that does make it quite difficult to juggle, particularly if you're looking at a transaction, for example, that straddles two member states. Now, to some extent, the court has addressed that a bit by the so-called doctrine of direct effect, which means that if the terms of a directive are clear, then actually member states don't have any leeway in the way that they apply it in their domestic law, and one looks at actually what the directive says. So the question that we're asking ourselves, and perhaps you can ask yourselves about the main the main benefit test, is it sufficiently clear and precise to say that we just have to look at that, or do member states have some ability to address the issues in their own way? So if we turn to the language, the main benefit test, I think, as everybody knows, says that the main benefit exists if one of the main benefit or one of the main benefits, having regard to all of the facts and circumstances, a person may reasonably expect to derive from an arrangement is the obtaining of a tax advantage. Mm. So the main benefit, or one of the main benefits of an arrangement, must be a tax advantage. And the job of lawyers is really to unpick the language and try to understand exactly what that means. Now, in general terms, a lot of it sounds quite familiar for us, to us, because it borrows from other sources. So perhaps the first question that we want to ask ourselves is, what do we mean by a benefit? And how do we understand benefit in this particular context? And does it mean the same thing, for example, as we have it in domestic law or in other instruments? We also have this problem, which exists, as you know, in anti-avoidance legislation generally, of trying to work out where there is more than one benefit, which one is the main benefit, and if there are multiple benefits, is it one of the main benefits? And that is something that has certainly exercised the courts in the United Kingdom. We've not necessarily had entirely satisfactory answers, and indeed we've had the Court of Appeal in a case called Lloyds Bank Leasing, where one of the judges said that this question had been addressed by 9 different judges in the course of the litigation as it went up and down the appeal system, and all had a slightly different take on the subject as to what is one of the main benefits. And the court said, well, this is no way to make a law at all. And what they also said is very interesting, and that is that it was entirely proper for both HMRC and the taxpayer to dispute the issue because of the difficulty in understanding. So I think that that does give one a little bit of unease about this type of approach to something where you've got quite a strict approach, backed by penalties imposed on, a number of people in this situation. The other questions that the language raises is that what we're looking for is the benefit that a person may reasonably expect to derive. So what do we mean by a person? Do we mean a hypothetical person? So just looking at this through the microscope or the telescope to see whether anybody might reasonably expect to derive a benefit, or do we look at whether it is actually the person who is the promoter or the implementer of the arrangement? Who is it that we're talking about? And if it is hypothetical, then it is a more objective test. If it is the specific participant in the arrangement, then there is an element of subjectivity in there. Now, it's obviously not entirely subjective, because whether it is the main benefit is to be judged having regard to all of the facts and circumstances. So that is clearly objective. It's not just what you say. I think the main benefit that I get out of it is X. So that part is made objective, but it's far from clear whether actually what is expected is judged by an objective standard or by a subjective standard. Now, the recitals to the directive do suggest that it is more of an objective standard, but I think that is something that certainly remains to be seen. The other undefined term which we often have to grapple with is tax advantage. What do we mean by tax advantage? And that is something, again, there's nothing in the directive that tells us what it means. So there are 2 things. Firstly, can member states adopt their own meaning? And secondly, will the Court of Justice either think that they've defined it too widely or too narrowly? So that raises, I think, an element of uncertainty And certainly, if, when one is advising on this, it would be something that you would worry about. And also, when disputes start to emerge a while from now, how does one actually resolve those kinds of issues?
So just before I go to Robert, one question I had, follow-on question, Jonathan, for you is, so last year, there was a case, Curzon Capital, which was at the first tier tribunal stage, which actually dealt with the topic of what is a promoter in the context of the DOTAS scheme. Now, that term promoter is clearly being taken across into DAC6. So what standing, should we look at that particular case to inform our understanding of DAC6?
Well, I think that this does raise this question of the interaction between European and member state law. And I think that in the first instance, it seems to me that you do have to look at the way the member state implements the directive. So in the UK, we will be looking at the directions, at the regulations rather, and it would be foolhardy, I think, to try to form an independent view, for example, as to what you think any of these words mean, because that puts you in a confrontational position with with HMRC. So I think that one does have to look at the way that the member state has tried to implement it, but always you're thinking about, am I going to be safe in doing that? What are the issues that are going to come if there is reporting in two jurisdictions, for example? Are there slightly different standards that might apply to me? So I think those are the...
Sorry to interrupt, Jonathan, because that's a really important point, because I think you've given an expedient answer that it will keep the HMRC happy. But is that what was envisaged by the directive itself, that you would have multiple interpretations which are localized?
Well, I think that is answered by the question, to what extent are the terms of the directive clear and capable of being given direct effect? I think a number of people have observed that it doesn't seem to have a very lawyerly style of writing. So one of the things which I know we will talk about is the connection between the main benefit test and the other hallmarks, which is a bit of a spaghetti to try to connect all the bits, frankly. So, I think, one does have to obviously be mindful of member state law when you do this and how they are thinking about it, because also remember, they're the ones that have to implement it. Indeed. They're the ones that have got to enforce it.
So, Jonathan, you raised some very interesting points, and I'm going to now invite Robert, who himself has been a lawyer, is a tax lawyer of great standing in Germany, and I'm sure I can completely, fully appreciate the challenges that Jonathan was talking about, where you've got a tax case going up and down between the lawyers. They can't decide what does main mean, what does advantage mean, and so on. And yet you, Robert, have to advise your clients, and many of them are not lawyers, and they don't appreciate this. How do we practically implement this? That's the first question. Then the second question is getting to, the importance of main benefit tests as it applies to the different hallmarks, and the importance that it plays within the DAC6 sort of like environment.
Thank you very much, Ali, for the kind introduction. What I've just learned, and I will definitely leverage upon, is, let's say, the phrase from Mr. Schwartz, the spaghetti test, in the context. And I think this is what I really bring forward to the clients if we have to discuss, let's say, DAC6 on other occasions. I'm very, let's say, from a legal training, etc., of course, German-minded, and let's say I think let's say the local interpretation of DAC6 directive is quite interesting. And what always strikes me is that we have these very specific hallmarks, which really have quite a very obvious alignment with anti-avoidance regulations. And then we have these very generic hallmarks. And up to a certain degree, it was my understanding when I wrote the, let's say, not only the directive on how it emerged, but also the German, let's say, reasonings of the implemented law or enactment, that the idea was to address aggressive tax planning. But the adjective, let's say, aggressive tax planning or aggressiveness got somehow lost, and the tax authorities recognized that with the, let's say, broad scope of the general, broad application of the generic rules, they get a fantastic tool to gather as much information as possible. And this has, at least in the German, let's say, environment, clearly expressed by the, let's say, tax authorities. So, to put it shortly, again, is we have this, let's say, these specific hallmarks without main benefit test, and then we have this very broad, let's say, generic or quite broad generic hallmarks. And the idea, at least at the beginning, my understanding was somehow to get a good filter function, that we have still an alignment with somehow aggressive tax planning. But via the implementation and the ongoing discussions, and then now with the spaghetti test, the really, let's say, from a risk perspective, the more and more the filter function, really to drill it down to some, let's say, GAR, let's say, structures or GAR, structures is somehow lost. And we are now in a stage where much more, let's say, much often the main benefit test will not apply, and therefore reporting is necessary. And this has been clearly reflected now in the German draft decree, but it's more or less already a final decree, where it's clearly said, okay, the general, let's say, reasonings for the GAR regulations are not applicable. Only, let's say, the range for DAC6 reporting is much broader, and that's how we have to live with it. If I, let's say, advising clients, really to establish your own legal reasoning, very strict on the wording or the original, let's say, reasoning of the law, quite risky. So probably broader scope of reporting would be, let's say, safer from this perspective.
Yeah, I mean, the point though is, Robert, the MBT shield or the threshold, it has different nuances and powers and potency when it comes to different hallmarks.
Yes.
So when we're looking at, so for example, the generic hallmarks, there is a really important role that the MBT plays.
Yes.
Whereas when we're getting into, say, for example, hallmark C, it becomes very specific, and you have to do a lot more mining and sort of like seeing if MBT applies or not. So in that kind of situation, if you're telling me that the Germans have taken a minimalist approach to MBT, how is that going to play out? Because I'm certainly sitting in the UK, and I'll let James come in with some of the practical challenges, but we're taking, relying very, very heavily on the MBT to give us protection against reporting under, say, hallmark A.
Yes. So the question is, if there is for the generic hallmarks, if you have a tax advantage, then you are very, very quickly, or that is quite a substantial risk that you might be asked why, and you do not report. And at least you have to have good reasons documented, so that if these questions are addressed why you do not report it, you can really bring forward let's say, documentation or reasoning that one of the main benefit tests probably was tax, but you have an somehow overwhelming business reasoning why you conduct the specific structure or the specific range for the specific, let's say, intercompany payments, etc.
So I'm going to ask you a very specific question, and I'm not a German tax advisor, so I don't know. But what we're hearing in, say, for example, in the capital markets industry to do with securities lending transactions, I mean, generally, we have got to a position with the help of, say, for example, our trade associations, into a position whereby the flow business on a securities loan gives us sufficient comfort that we're not going to be reporting. And we've gone through the different hallmarks to satisfy ourselves. Whereas what we're hearing on the German side of things is that every single securities lending transaction is potentially reportable, and people are working towards that. Now, that seems, to me at least, overkill.
I would put it this way. Let's say securities lending on a very pure standalone basis. Yeah. It's more or less a one puzzle of an overall structure, and you have the knowledge of the overall structure, and you know what is the economic outcome of this structure, probably some withholding tax optimization, etc. And this is, let's say, either the clear intention of the overall structure, where securities lending provided by, let's say, intermediaries is just a tool to conduct these transactions. If you have the knowledge of the overall, let's say, intention, probably reportable, because that might be a tax advantage. And if you are an intermediary, lending desk, etc., and you have very specific knowledge of the trading strategies of your clients at a very specific, let's say, over a very specific dividend date, etc., you at least probably have to analyze it. And then you cannot just rely that securities lending as such is a commodity
Let me ask you a question, and this is a very quick answer I want on this, Robert. It could have the environmental factors, the context in which, say, Germany is interpreting securities lending. I mean, there is that word COMEX that comes to mind, which is a little bit of an issue that with the German authorities. Is that perhaps having an influence in the thinking of intermediaries and also the tax authorities in how they're applying that to that particular transaction?
It is not really clear, especially how they are applying it, but they are giving no safeguarding, let's say, reasons or safeguarding interpretation that very specific transactions will not be within the scope of the DAC6 ruling. For example, there had been some discussions within the, let's say, tax authorities, how to establish or what topics should be covered by the so-called whitelist. And various, let's say, structures were being asked by various tax authorities to the very specialized, let's say, department in the Ministry of Finance, that some investment structures should also be, let's say, regarded as non-reportable. But let's say these departments mentioned no. There will be no per se clearance for non-reporting for such structures. It is our understanding. Other local, let's say, tax authorities, they clearly addressed via DAC6 they can gather as much information as possible, and beside the, let's say, implementation of DAC6 as such, there has been some additional regulation being implemented in German law in respect of the reporting to be conducted within your, let's say, within either personal or within your tax returns. So that there is a clear, very easy alignment now between, let's say, the European DAC6 reporting and then analyzing and information of the tax authorities as such, but via the very specific, let's say, implementation within the tax returns, or in addition, the local tax authorities, tax audits will be aware of these structures, and they can prepare much better for the tax audits clients will face in the future.
I get the purposive approach. And just turning to the practical issues, and now we heard, James, that the Germans have been really helpful, the tax authorities, by publishing this whitelist. Can we expect a whitelist with all transactions to do with Cayman Islands?
So I think, excuse me, I think the UK's approach is not going to involve publishing a whitelist. I think our preferred approach is to look at the regulations and the directive, and rather than sort of saying inherently certain products or types of transactions will or won't be, saying certain products definitely won't be caught. It's a question of looking at the circumstances of a particular arrangement and reaching a judgment about whether that arrangement would be reportable. What we've tried to do in the guidance is to try and draw out what the sort of principles are that we would be considering and that we think people as a promoter or a service provider would want to be considering in trying to reach that judgment. But we think, a whitelist of, as you suggest, sort of transactions involving the Cayman Islands, for example, seems to us to be difficult within the scope of the directive. So that's our preferred approach.
Then I raised Cayman Islands on purpose because that's where hallmarks see certain elements with the sort of like non-cooperative jurisdictions. It doesn't give us the protection, and that's obviously created a lot of concern within the marketplace. And is that something that HMRC is specifically looking at, or are you being contacted by taxpayers, intermediaries, just on that particular challenge that people have for that? Because it would seem, in fact, actually, to me, it highlights the importance of the MBT.
Yeah, so it is something that we're very much aware of and have been contacted about. So what our approach has been is particularly in relation to the period from June 2018 through to the 1st of July when the regulations came into force. In looking at that period, we've sort of clarified in guidance that we would consider that a jurisdiction would need to be on the list both at the time of the transaction or the time that the reporting obligation would arise, but also at the time that the report would actually sort of be required. So we hope that would provide some comfort in relation to that sort of look back period. But going forward, the challenge is, I guess, that it is a deliberate choice for the main benefit test not to apply to certain hallmarks, and I don't think we can read into the directive that it therefore should apply to those ones. So it is intended to capture relevant transactions involving those jurisdictions on the list. And I don't think I think to deviate from that position would seem to be inconsistent with what was set in the directive.
Okay, thank you very much, James. Now, obviously, we have seen that particular situation where under hallmark C, when MBT does not apply, it does create a lot of problems. Okay, now turning our attention to when we do enjoy the MBT, it provides a big cover, it's a threshold. And Jonathan, I would like to invite you, because there was clearly quite a lot of discussion when BEP Section 12 final report was being put together, because I think at least at that level, at the OECD level, there was a concern that if a threshold requirement like MBT was to be introduced, it would essentially render the whole disclosure regime, it would take all the teeth out, because nothing would be reportable on a cross-border basis because it's such a high threshold. Would you care to comment on that?
Well, I think that the OECD did see difficulties with this, but to some extent, I think the directive has moved on in a way from BEPS Action 12. And I think what is different, if I can deal with it in this way, for example, between the UK DOTAS and this, and that is that disclosure in the domestic context relates purely to the effect of a transaction under UK tax law. And that is one of the big differences between that and this, where in deciding whether there is a benefit, what is clear from the recitals at least, if not the text itself, is that you need to look at the combined effect of certain transactions. And this is why, for example, the combined effect of a deduction in one jurisdiction and non-inclusion or receipt in a low tax jurisdiction is something that is engaged here. And that is very different because the traditional approach to tax was that each country looked at their own system. And if you look at some old-fashioned structures that seemed to work at the time, you would say, well, each one works under the tax law of the countries that are involved, but it's only when you look at the combined effect that you might say, well, hang on, there's less tax being paid overall as a result of that combination. And that is a very new development, which I think is certainly manifested, at least in the context of disclosure. It's in a more limited way, I think, in relation to tax law. We see this in the UK in the diverted profits tax area, for example, where the combined effect is now important. But I think that part of the purpose of this is actually very wide coverage of the kind of arrangements that might be undertaken internationally or cross-border.
That is really interesting because just working on something myself at the moment, when you're looking at, say, for example, a complex private equity structure where you've got 400 entities, fund entities, the carry structure, the asset management structure, you can take a component element and you do a grassroots analysis. But then, as you say, this composite effect needs to be also looked at. So you're almost, it's like one of those long-range zoom lens that you have to keep on going in and out continually to basically make those determinations. And I think practically, as you say, it is a really difficult exercise to implement because, it's okay for tax advisors to be sitting and talking about this. But, trying to operationalize it where you've got sort of like the front office colleagues and financial institutions trying to implement it is really, really difficult. Now, with that, I'm just going to go and invite, all of the panel to just there is obviously this other big development that's taking place at the EU level, which is the Anti-Tax Avoidance Directive, ATAD. And that will have an interesting interaction with DAC6. Perhaps, Robert, you might want to sort of like kick off that discussion.
Let's say, put forward probably quite a aggressive idea. Currently, we are discussing, and let's say from an advisor perspective, also from a client perspective, somehow, let's say, complaining that there will be additional tax reporting due to DAC6 with the implementation of the anti-tax avoidance directive in various countries. Probably it will not be additional reporting, but let's say, additional taxes, and this will reduce ultimately maybe the reporting requirements, but it will increase the tax burden. So it's very bifurcated, or the interaction between these two, let's say, directives will be quite interesting how this will work out. Of course, if you will have the opportunity via new structures to somehow avoid, let's say, the increased tax burden, what Mr. Schwartz has described, let's say, the overall, let's say, structure have to be analyzed not on an isolated basis, but in its whole context. There will be an additional might be still an additional tax benefit, and therefore, let's say the new structures will be reportable. But many old structures will not be reportable anymore, but will be taxed. And this gives, let's say, retroactively, the tax authorities the opportunity to challenge or to analyze which structures should have been reported, which are now, let's say, 22, 23 taxable.
Well, it's interesting because if you go for, say, for example, the denial of the deduction,
yes,
under 8ed, that would then trump DAC6, and you wouldn't have to, because there's no deduction.
Yeah.
Anyway, that's an interesting thing to look out for as to how that market evolves. I'm just conscious of time, so I'm going to just ask Jonathan, you have 2 minutes in which to cover, 3 minutes in which to just share with us your thoughts about just on this point, 8ed, and also if you could just say a little bit about, where you see the Brexit thing going.
Well, I think that is the feature of the way that things are developing at the moment, that we do have overlapping regimes that talk about the same sort of thing. And that clearly raises a level of complexity. In the cross-border area, you've got the domestic specific anti-avoidance rules, you've got domestic general anti-avoidance rules, you then got the ATAD in the EU, you've got the PPT in the treaty context, all in the same general direction, but saying slightly different things and having slightly different applications, which does raise complexity. In the long term, this is part of the spaghetti, which is probably not sustainable, but I think in the short term, that is really what we have to try to manage.
And so us leaving the EU, would that help avoid the spaghetti?
No, I think it just gives it a different flavor, because I think there are really two issues. The one is although the Mutual Assistance Directive, of which this is a part, is included in the withdrawal agreement, so the UK has agreed to implement it. That is no longer a matter of European law, but a matter of the withdrawal agreement, which, as you know, the government takes a selective approach to compliance with. And I think connected with that is the power that they have given themselves in the Brexit legislation to disapply EU law and decisions of the Court of Justice, which they don't like. So I think that does raise, again, another bit of uncertainty. I think the bit of uncertainty on the other side of the channel is that if you look at the recitals, two purposes of the DAC6 are, firstly, to prevent diversion of profit to third countries, which the UK wasn't when this was enacted, but it is now. And connected with that, of course, is the sensitive issue of state aid, also a British invention, actually, and a requirement that the UK imposed for the creation of the single market, and the extent to which the UK will want to create tax incentives that might create those kinds of problems, and also the fact that another purpose of the directive is to facilitate the functioning of a single market to prevent the kind of mismatches that have developed in the last decades. So those, I think, are the two Brexit issues that we have to grapple with.
Indeed, indeed. So if I can finish off with you, James, I mean, we've had a really interesting discussion, and there's so many more things we could have discussed. But, on that final note regarding somewhat the selective interpretation and application, I mean, where does that leave you at HMRC in terms of, preparing? Is it all going to be over and we don't have to report under DAC6 in whatever 12 weeks time?
Yeah, thanks, Ali. I think the short answer is that I can't give you a definitive answer. The application of directives, as I'm sure you're aware, is a feature of the negotiations between the UK and the EU. So while those negotiations are ongoing, there's not really much more I can add. That is, it is a feature of the negotiations. So we'll have to see.
So we should continue as before.
Well, certainly it would be a bold move to assume that you weren't going to have to start reporting. But as I say, with the negotiations ongoing, it's difficult to say anything more than that.
Yeah, I appreciate you are somewhat constrained in what you can say, but I mean, I can probably take a view on it, which is, I think, sort of like the very active role that the Brits have played in, moving forward on tax measures. I would be very surprised that there would be any climb down on that. I think Jonathan raises some really interesting points about particularly the third country status, as to, if they're reckless enough to go down this sort of like, race for the bottom when it comes to tax rates and things like that, that clearly would kibosh the whole arrangements and so on. But I think the expectation is certainly that these mechanisms will be there and they're being developed. And if I can read something in, the fact that, James, you're there, you've got a team of people who are working there, who are supporting, to me that shows a certain trajectory or line of thought. So anyway, with that, I just want to sort of like firstly thank our panel. They have done a really, really excellent job, and I wish I had more time to pick more and discuss more things. And it is with I'm not saying goodbye to just this panel, but it is with a heavy heart that we are actually sort of like bringing our 12-week DAC6 Academy to a close. A very big thanks to Robert and our friends at WTS, Mr. Stefan Gnutzmann and Robert have been a real strength in pulling this program together. So I really enjoyed myself. It's been a fantastic 12 weeks. The beauty of it is obviously we've got the recording, so those members of the audience who didn't attend some of the other ones, please do look into it. It's a really fantastic library, a lot of really good speakers. We had 20 speakers during the 12 weeks. We made 871 new friends who basically attended this whole series. So it's been a really fun time. And as I said, it's with a heavy heart that I say goodbye. But I can point towards the third week of November, we are going to be hosting our Financial Services Tax Conference. So please do attend that, register your interest. If you can, I think we have the list of all our programs, the 12-week webinar series, but also we have list of Lucas, I think we've got the contact details. If you're interested in attending the Financial Services Tax Conference, please do express, send your expression of interest to that. Again, thank you very much to the panelists. Really appreciated you taking the time, and good luck and have a nice day. Thank you.